May it please the court, Jeffrey Geldin, Assistant Attorney General here on behalf of the appellant, State of Florida. Because of the appellant, I asked for 2 minutes of rebuttal, please. The trial court erred in dismissing all 3 counts because as to count 1, well first I'll explain the facts as they're laid out, because part of our position is that the trial judge assessed the facts at the C4 motion to dismiss stage. I would like to note that in the brief, it's not as clearly delineated between the 3rd and 4th transaction. There's the 4th transaction, which is actually the attempted transaction that's discussed in the reply brief and in the initial brief and the response brief, because that transaction was in person. The 3rd transaction should actually be the transaction that occurs via text message, and that's the Citibank transaction. It really doesn't matter in terms of the legal argument, but I did want to clarify that for purposes of understanding the facts. It's laid out in the trial court's order, but again, as we explained in the brief, and as I said earlier, we think that the trial judge assessed those facts incorrectly at the C4 stage. With regard to count 1 is the money transmitting statute count, and our argument is that Bitcoin counts as monetary value for purposes of that statute, and that because any person who acts as a money services business without a license triggers the criminal provision under the statute, because they're supposed to have a license.
If this transaction had been done by credit card rather than cash, would it have been subject to Chapter 560? If Detective Arias had charged his credit card instead of paying cash, would it have been subject to 560?
I think it still would, because that would be he would still be getting paid in funds.
Really? Okay. So that I'm clear then, it is the state's position that any person who sells their Bitcoin to another person for cash is subject to licensure under Chapter 560. Is that correct?
Any person who sells it through either person-to-person transaction, correct, peer-to-peer. Not if they do it through an exchange, which is how we distinguish the Coinbase authority that they cite. If you do it peer-to-peer in person or
correct, a two-party transaction.
Correct.
And you buy my Bitcoin, you pay me cash, I transfer the Bitcoin to you, I have to be licensed.
If you hold yourself out as a seller of Bitcoin.
No. Where is that requirement? Where is it required that you hold yourself out as a seller?
Well, it says a person may not engage in the business of a money services business. So it has to be business. So you have to hold yourself out as doing it. In the business of money.
So you must be holding yourself out as conducting that type of business regularly.
Correct, and that's what we have here. At least at the motion to dismiss stage, we have the website advertisement saying, if you need Bitcoins, I have readily available Bitcoins. I can get them for you. Here's what my fee is.
How is that different from someone who advertises their secondhand car for sale?
Well, first, that's a car, and our contention is that Chapter 560 sets up a regulatory scheme.
Versus being a car dealer.
Exactly. Or a seller of real estate, or any type of regulated profession where you're getting a commission for selling particular products that are registered. The example that the trial court used of a day trader, we think that that's not a good analogy because for the same reasons. If you trade in stocks, even if you're a day trader, first of all, if you're a day trader, there's certain SEC regulations that the site that you're trading through would have to enforce over a certain volume, et cetera. That's not in the record, but for purposes of understanding the difference in the analogy, I'm explaining it. And similarly, if you're going to be a real estate seller, you have to sign up under the state of Florida's regulatory business. I believe it's the Department of Professional Regulation that deals with that rather here than the departments that issue here.
The definition of money services business, which is paragraph 22, subsection 22 of 564-3, says means any person located in or doing business in this state, from this state, or into this state from locations outside the state, who acts as a payment instrument seller, foreign currency exchanger, check casher, or money transmitter. So where does it require that they be doing business within the state of Florida in order to be subject to licensure under Chapter 560?
Well, I think if you read any person located broadly, then yes, in that situation. But again, as it applies to this case, you have multiple transactions.
I'm asking you about the applications of facts outside this.
Yes, exactly. If you were to read any person to include...
It says any person located in this state. It doesn't require doing business. It says or doing business in this state. Any
Correct.
person located in this state.
Correct.
And that means everybody.
Exactly, if you do certain things in the state.
So if I
exactly.
sell you Bitcoin in
Peer-to-peer.
exchange for cash,
Correct.
peer-to-peer, I have to be licensed under chapter 560, don't I?
Correct, that would be, that has to follow from the language of the statute, that's
That
correct.
also means that I have to have a net worth of at least $100,000 under chapter 560 in order to get a license, yes?
I read this, the licensure requirements. I did not see the net worth requirement, but if you could, I believe you're talking about the 560.141.
What's the bond, is that the
You have to
requirement?
post, you have to post a bond, right?
Is that in, that's in 560.141, Your Honor?
560.29. You have to have a net worth of at least $100,000. You have to obtain an annual financial statement. You have to provide a corporate surety bond before you can even get a license.
Correct. You would
So
have
the
to-
likelihood of me being able to sell you Bitcoin for cash in compliance with law is pretty much zero.
If you choose this mechanism, if you go through Coinbase, and that's why their expert explains that. Their expert at the testimony says,
Well, how else do you trade it in Bitcoin or sell Bitcoin without using some electronic digital format?
well, through the website, the Coinbase website, it's authenticated, and they basically broker the transaction for you. Their expert explains that. The record 141 in the testimony, and that's the 141 is the record at the bottom of the page. He talks about how he trades in Bitcoin. He says, I sign up, they authenticate me, I give them cash.
Right.
They comply with the regulatory requirements, and then the person who wants to buy it from me buys my Bitcoin through that site, through the third-party exchange. Those people are licensed to do that. If you do it peer-to-peer, you're circumventing that scheme, and thus preventing the regulations that are necessary for this. Again, this is and as their expert explained, the reason he uses Coinbase and the reason that there's sites such as Local Bitcoin is because of the risk of fraud and consumer issues.
Well,
This
there's
is
a
a-
registration requirement to participate in that site, correct?
Correct, Your Honor.
Buyer or seller.
Correct, as explained by their expert, and I haven't independently tried Coinbase, but as explained by their expert, there is a registration requirement. You give them your information because they themselves submit to the regulatory requirements, as we know from the submissions that have been placed in this case about Coinbase itself and other type of sites. So for purposes of that scheme, you have an exchange. So while it's correct, Judge Enos, that in a context like this, a local Bitcoin thing, you would be in trouble. You could still sell your Bitcoin. You would just have to sign up for it through the website. And again, our argument is that the ill that the statute is trying to avoid is the type of fraud and other unregulated things that go on if you don't have a license to exchange it, to deal in this type of transactions.
Why shouldn't that be regulated by the Commodity Futures Commission?
Well, there is some overlapping regulation. It depends upon how you treat it, but even the Commodity Futures Exchange, and I think they cite the FinCEN regulations, talk about the facts and circumstances of the transaction, determining whether or not it triggers the regulations.
So in one transaction, it may be the sale of property, a commodity that has some speculative value, and in another, it may be a form of payment for a good or service.
Correct, and our argument here is that it is in fact a form of payment because of the way that the detective manifested the purpose for which he was using it. If you're engaging, and I think there's websites that do that sort of thing, that engage in futures of Bitcoins and the like, that's a little different, but again, even then, that's being done through a commodities future regulated exchange or an SEC regulated exchange, and that's the difference. Again, the point here is the licensing scheme is there because you want to make sure that people aren't engaging in the trade of monetary value or payment instruments without licensure or regulation, and that the market itself can be regulated, and the way that it's enforced is through fines and criminal
Would
penalties.
this apply to gift cards or gift certificates? Say you got, $1,000 worth of gift cards to the mall for your birthday, and you wanted to advertise and sell those. Would this statute apply?
My recollection of the statute is it exempts gift cards and other things that are redeemable for services as from the definition of payment instruments, so I think the answer to your question is no.
Well, redeemable for things that you could buy at the mall, the same way Bitcoin is, you can buy things with that, other than exchange it for cash.
Well, in the situation of the mall, and I think that's why it's exempted, is there's specified goods and services that you can buy it for. It has to be, Daylight Mall or, service merchandise, dating myself there, but, Target or whatever it might be in that situation. That's a limited thing. Here, it's boundless, essentially. As the expert testified, the expert said, you could buy, there's restaurants that take this, there's, economies, he actually used the example of economies in Africa, where that's used instead of banking for purposes of the medium of exchange. So I think that the example of that, in addition, if you don't believe that the exception for banking for goods and services of value applies, would be such that it's not of the same character. And again, going back to Judge Salter's point about the facts and circumstances dictating whether or not the transaction is regulated.
So you concede, I think, that Bitcoin is not currency, at least as defined under Chapter 560, yes?
That's correct.
That in fact it's monetary value versus currency.
Correct. It's monetary value, and in the instance of the transfer of the specific things, it's an electronic payment instrument because
Right.
it recognizes monetary value. And again, it may not necessarily be negotiable. That is, you can't redeem it for a specific amount of cash.
Which is the point of the monetary value definition. It's pretty broad, right?
Exactly, Your
It's
Honor.
a medium of exchange, whether or not negotiable, into U.S. currency.
Correct, Your Honor.
Right. So that's a pretty broad definition.
Correct.
In Chapter 560. So a medium of exchange is different from the definition of currency, which talks about U.S. coin and currency of the United States customarily used as a medium of exchange. Right?
Correct.
Okay. So if monetary value means any medium of exchange, which it sounds like that's what it means, whether negotiable or not, whether
Correct.
redeemable in U.S. currency or not, I would assume that you would agree that gold is also it would constitute a monetary value, would it not?
Well, I think it would, and I think we cite a case, if I remember, it's United States versus Eagles, where they tried to make that argument and the federal court rejected it, saying, yes, gold is a means of exchange.
And diamonds would be a means of exchange, would it not?
I think if gold is, the diamonds are as well, yes.
So if I decided to get out of selling Bitcoins and instead I went into diamonds, and so I sold you a 2-carat diamond and you paid me $5,000 in cash, would I be subject to license? Would I be required to be licensed under 560 to do that?
Well, I think if diamonds are a medium of exchange, then yes, you would have to go through
Well, you just said they are.
Correct, yes. So in your example, yes.
So I couldn't sell you a 2-carat diamond for $5,000 without first being licensed under Chapter 560.
Well, I think, again, back to the facts and circumstances of the transaction, if you were just selling, yeah, I think we go back to...
Let's call it a good or service. Is
It's,
it subject to licensure?
no, it would not be, because a good or service is not a medium of exchange. And I think we go back
Let's
to...
say I sell it to you as an investment. You want to hold on to that, you think that the diamond is going to rise in price, and you want to hold on to it as a commodity, precious metal, an investment, whatever.
Well, I think if you're holding it out as an investment of some sort and talking about the risk in investing it, then at that point you're triggering Chapter 517, if I remember right, the securities laws.
Would I have to be licensed under 560 to sell you that 2-carat diamond?
I think in isolation, no. I think you have to determine the facts and circumstances of the case. So we would go back to Judge Lindsay's example of the secondhand car on the front lawn. And actually, as I recall, the expert testified to that.
I'm not asking if the state of Florida would enforce that sale or enforce the licensing provision against it. I think that's where you think I'm going. I am asking you whether under the plain language of Chapter 560, my sale to you of a 2-carat diamond in exchange for your giving to me of $5,000 in cash would require a license under Chapter 560.
I think if the record demonstrated that the diamonds themselves were a medium of exchange, then yes. For example, in the Eagle case, it was a gold exchange that they were involved in.
So
and
barter,
trade.
certain types of barter where diamonds or some other good are used as payment might be subject to it.
Correct.
But you'd have to establish, I guess, some type of market or ready source of buyers and sellers, and in this case, Bitcoin has buyers and sellers.
Exactly, that's a prima facie matter. And again, whether or not it's actually that, and I think the case that we cited a case out of the second district, the Feldman case, which involved the determination at the motion to dismiss whether it's security. And they said, you can't do that. You have to look at the facts and circumstances. You resolve an issue of fact in terms of what the people to the transaction were dealing with.
But now I'm completely confused. What then what meaning are you then attributing to the phrase medium of exchange? If you're distinguishing between a payment for a good or a service, which I think you're saying is outside of Chapter 560?
Well, I think it would depend on what the good is. And the medium of, I think that the way that the statute is written, it calls for a factual determination. The way that the statute is written says a medium of exchange, whether or not negotiable, in terms of for the payment instrument part and for just generally using the medium of exchange, it calls for a factual determination. So again, Your Honor, In your situation where it's a one-to-one transaction, I just happen to like diamonds, I'm buying a diamond, I think that takes us back to Judge Lindsay's example of, I see the car on the front lawn and I really like the car and I'm buying it. I don't think she has to be licensed as a car dealer. So at that point, I think that's the distinction. I think that the way that the statute is written, it calls for some form of factual determination. And here, the facts, at least as a prima facie matter, demonstrate that that was the purpose. Mr. Espinoza goes on this website and says, Bitcoin is, this is Bitcoin, it's a means of exchange. I'm going to sell it to you based on the market value of that means of exchange. Here's what my price is. Can you meet me in person? And then you have their expert testifying at the hearing talking about the reason for that. The reason for that is because people want to meet in person because they don't want to get defrauded. That links us back to the regulatory scheme of, in terms of people selling this, the state of Florida has said that these type of things should be regulated for purposes of consumer protection and for purposes of regulating currency or other economic value in the market at large. And that's our contention with regard to why you would read this broadly. And we cite the cases about lenity, et cetera. But I think Your Honors don't have any other questions, so I'll go ahead and save the rest of my time for rebuttal and stand on the brief as to the other counts.
Okay.
Thank you, Your Honors.
May it please the court, again, Mr. Salter and Judge Lindsay, good to see you. Your Honors, when this case came up, it's a very, and I apologize, I'm a little bit under the weather. My throat's a little bit dry and a little congested, but if I'm not speaking clearly, please let me know. This case creates a very interesting issue. The supplemental authority, and I apologize, I filed late yesterday, discusses the multitude of regulatory agencies that are trying to regulate Bitcoin and its usage. And I think the overall consensus from all the court opinions dating back to when the Silk Road cases, the dark web cases first developed, shows some type of fear by governments, by...
Absolutely, there's a out there, and even before the supplemental authority, there's a very clear concern about money laundering, about traceability, the ability, because our monetary system is set up for wire transfers that are monitored, whether it's a bank or Western Union, and there's a difficulty in hauling large quantities of currency or krugerrands or whatever else around. So
Correct, Judge.
the concern is you can make value, monetary value, appear in a different jurisdiction across the world.
Correct.
So that's the concern.
And I believe that's why there's been such a race either to regulate, or what happened in this particular case was, and I believe this is contained in the record on appeal, and I believe the judge also mentioned it, I know we discussed it at the argument for C4, the particular detective in this case from the beach worked with a Secret Service agent after they had just gone to a seminar where they learned, law enforcement says, hey, this could happen, and they went troll. And that's how they came across Mr. Espinoza. But I think that
Then doesn't that kind of take it into the type of situation that isn't resolvable at the motion to dismiss or the C4 stage? Certainly under the securities laws, as your opposing counsel mentioned, there's a myriad of case law, determining what is a security and what qualifies as a security for purposes of the securities laws.
Yes, Judge, and where I think the panel addressed or addressed with the state a little bit, it really, why it's, at least for the money services business aspect, the unlawful money transmitter, I truly believe that when looking at the statutory screen, and it's been already developed a little bit, that the sale of Bitcoin, Mr. Espinoza's personal property, to the detective does not qualify under the statutory definition.
Well, the IRS treats it as property, and
Right.
now the state's wanting to treat it as, a medium of exchange. So all the agencies, CINFIN has a slightly different take on it, on the Mergio case. Everyone's sort of looking at it a little bit differently.
Right, and I think that's the issue, is that nobody, or at least no courts or regulatory agencies have. I think it is the Bitcoin itself, and thank gosh for the amicus brief, because I really think that they kind of break down the technology a little bit behind it and how it can be used. And I think that the problem here is that it can be used in many different forms. It can be used as a medium of exchange. I believe that our expert said that during the C4. It can also it has in the recent opinions, it can also have, be regulated as a commodity, because you've had future trading companies prop up that, unfortunately, some have been fraudulent. And I think that the regulation of the Bitcoin is coming from, obviously, the fear that there can be fraud. And to go back to what Judge Lindsay, what you were saying, is the potential for fraud, or maybe Judge Salter. The fact of the matter is, and this is discussed in the amicus brief, the fact of the matter is, the technology that goes into the Bitcoin, which is the blockchain technology, the reason why, and the government addresses, what they want is somebody to go through an exchanger, meaning a Coinbase, or in the exchange of money, we want like a Western Union involved, because then there's some type of registration. The technology behind the blockchain is that it acts as its own self-authenticating measure, or its mechanism. Correct.
It doesn't need the assistance of any intermediary to transfer.
It does not. The blockchain itself, the code contained, it's just software. What Bitcoin really is, it's software that self-authenticates itself using cryptology, and I would not even try to begin to explain the details.
So the question is, how do you follow the money though? Because it's a trusted, distributed ledger. So that means it can be anywhere. The servers that hold the information can be anywhere. The miners that do the authentication can be anywhere.
It can't, Judge, and that was actually addressed. Our expert testified to the case where actually two federal agents were investigating money laundering through Bitcoin and were subsequently indicted. And the computer forensics people, I believe it was the FBI, were able to go into the servers, because whether you use a phone, a computer, you need an electronic device to do this. And that device would create an IP address. And all this data and information gets put into the blockchain. So if you could find one purchaser or seller of Bitcoin, conceivably, with the right computing power and the right intel, somebody a lot smarter than me, you could find that whole chain of buyer and seller. Now, of course, you could run into the problem of, well, somebody could have what they call a VPN, a virtual private network.
Yeah, all of this is very interesting, but I'm not really sure it gets us to the point where we're at, which is to define whether or not your client is either a payment instrument seller or a money transmitter. So if we can,
sure.
How about if we get back to that?
Well, specifically, if we look at subsection 23 of Florida Statute 560, that defines money transmitter, which is something that was not addressed with the government. Money transmitter means a corporation, limited liability company, limited liability partnership, foreign entity, qualified to do business in the state which receives currency, monetary value, or payment instruments for the purpose of transmitting the same by any means.
So, you agree that the state is not proceeding on the theory that this is currency?
Correct.
All right. They're proceeding on the theory that this is either monetary value or a payment instrument or both?
Yes, that's what they're trying to say.
And why is Bitcoin not monetary value, which only means that it need be a medium of exchange, whether or not negotiable in U.S. currency or redeemable in U.S. currency?
Monetary in its traditional sense.
No, I'm talking about monetary value as defined by 560, 103, 21. Monetary value is a medium of exchange, whether or not redeemable in currency. How is this not monetary value?
It's not monetary value in the sense that, well, number one, Judge, to address that, it's a very broad definition, as Your Honor indicated.
I agree.
And I think anybody could say, well, if you can exchange it for a penny or a fraction of a penny, then it has some type of monetary value.
Green stamps.
Whatever it may be. So in that global, what I would consider an overbroad definition.
At one time.
Beanie Babies.
Beads.
Beads, lampoons, or
Long Island.
whatever we bought Long Island for $21, right?
Manhattan.
22, yes,
Should
correct.
bought Long Island.
And that's the thing. The Bitcoin has monetary value. Why? Because somebody decided it does, not because it's backed by any currency. I think that that's the problem with the statutory scheme. It predates the existence of something like Bitcoin.
Doesn't coin, though, suggest to us that it's monetary value?
It does, and that has just been a misnomer from day one, back in 2009 when the first quote-unquote coin was coined, or mined, and it really is just software, and that's really a misnomer.
Why would someone want to sell it for money as opposed to just buy things with it? It's a medium of exchange.
Well, because at this stage, Bitcoin is
Was
not,
your client arbitraging it, kind of
well,
looking at the fluctuation?
the facts below indicate that my client advertised on the back of, I think it was the New Times, said if you want to buy or sell Bitcoin. What Mr. Espinoza did, and this is in the deposition testimony, which is on the supplemental record, when the detective met with him, the detective said, hey, I know nothing about this stuff, explain to me how it works. And Mr. Espinoza explained to him and said, look, I buy Bitcoin and then I hope to make a profit off it. And when he's saying he marks it up, that's not a commission. That's the word of the detective. Saying, oh, well, he got a commission, which makes him in the business of selling Bitcoin. Mr. Espinoza has Bitcoin where he can make money, because the market will tolerate certain fluctuation up or down, depending on the buyer or the market, the tolerance of that particular buyer.
Okay, well, this is back to the point of, can you resolve this on a motion to dismiss? Along the same lines of, is something a security, is a factual question.
I believe it can, because under the definition, Mr. Espinoza did not transfer, he did not act as a money transmitter. The money transmitter statute, when you read it as a whole, talks about the money services business. That means person A goes to the money transmitter to send the money to somebody else. And I think that's where Judge Pooler was saying there's no third party here. And the government is correct in their brief that where it says the statute can say there has to be a third party here. But when you read the statute in its entirety, you don't, for the purpose of transmitting the same by any means, meaning transmitting what you were given from somewhere else. Transmit. What does it mean? Transmit means to move it. This is not a movement. The government wants you to microanalyze and say, oh, because we now have the technology to transfer something at the touch of a key, that qualifies as transmitter. Back when Western Union was created, you needed a computer the size of this room to be able to do the technology to send that money to the other Western Union, in Tampa, for example. We now have that technology here. This is not a transmitter business in the true sense of what the statute was meant to regulate. And I think that the only guidance we have, which we attached to our briefing, was the Florida Office of Financial Regulation, when they talk about this company that asked for some guidance, and they wanted to have this is in-rate petition for a declaratory statement of Moon Inc., where they described how their business would work. Okay, and in this particular sense, this business,
They denied him a license.
No, they did not, Judge.
Are we talking about Moon?
Yes, in Moon, what they said is they said, you don't need a license. You don't need a license. Now, what the government would say is, well, that's because they did have a third party involved in this, which was a money services business. But what this shows is these people were in the business of money transmitting. They basically, the way their business model worked, it looks like they would subcontract with a Western Union or money grant. In this particular case, the reason why we can resolve it at the C4 stage is because Mr. Espinoza was selling his own personal property. He was not in the business. And the facts and the record shows he is not in the
Wasn't he holding himself out to the public as wanting to buy and sell these?
Correct. Just as somebody would say, hey, I'm going to go buy a 65 Corvette if they could find one in a garage somewhere in the middle of the state. I'm going to fix it up and sell it. Anybody have an old car to purchase? That doesn't mean they're an auto dealership. Mr. Espinoza was taking advantage of a market.
If you did that with the old Corvette a number of times, under the DMV rules, you can only transfer title so many times in a year before you need a dealer's license, correct?
I'm not familiar with how many it would be, but I would assume, yeah, you can't, at some point you couldn't run that out of your house, because should the association, the county would say, you got 10 cars in the front of your house, you can't do it. But I'm not familiar, but yeah, if that's what you do day to day, and this is very important, there's no record evidence that Mr. Espinoza made a living, ran a business, ran a corporate entity, and did this all the time. Just like a day trader.
We need to ration time a little bit, even
Yes,
though
sir.
we're gonna give you extra time for sure, but could you speak to money laundering for a moment?
Sure. The money laundering aspect of this case, and the government raises the point that this is not reconciled to the C4 stage because you're trying to get into the intent of what was in the defendant's mind. Then that is the law. That's very clear, and they briefed at that point very well. However, this is Judge Pooler in the trial court looking at the record evidence, looking at the depositions in the case, looking at the actions of the detective, saying, I believe her order is pretty clear that says Mr. Espinoza sold his property, and the trial court found, based on the deposition testimony and the testimony presented, that even looking at the facts within the light most favorable to the state, the detective's actions and verbiage did not rise to the level that would establish the requisite scienter on behalf of my client. The other points we want to make as far as the money laundering is concerned, it's a little bit convoluted in the sense that count 2 of the information is the first charge of money laundering. However, count 2 of the information actually charges the final attempted transaction for the $30,000. And the reason why that can be easily resolved at this stage is because if we look at the definitional sections of money laundering, well, first of all, I would, in the appellee's answer brief, we'd cite to Rodriguez v. State. It's completely 100% clear that my client never took possession of the money, never transferred any Bitcoin for that money, and in fact, it's in the record. I can't point to it right now, but I believe my client actually suggested, hey, why don't we go to the bank, to the detective. Clearly, that transaction was never culminated.
Did you raise this in your C4 motion?
Yes.
You raised the absence of consummation for count?
In the actual brief, no.
In the motion.
In the actual written motion for C4, Judge, I don't believe that was in there. However, at argument, when the judge wanted to supplement, after we presented expert testimony, after we presented, the judge gave us one last hearing where we summarized everything. The judge said, I want to take into consideration additional evidence in the depositions and the deposition transcripts in this case, and it was raised at that point.
The use of counterfeit money in the consummation of one of these transactions, I think it was count 2, I want to say.
Correct.
At least that's what you argued in your answer brief. Is that raised in the sworn motion to dismiss? You ask us to tipsy coachman affirm this, at least as to count 2, because it's your position that counterfeit money was used by Detective Arias in payment, or maybe it's count 3, I don't remember, in payment of the transaction. Is that raised in the motion to dismiss? I'm assuming it isn't, because you're asking us to affirm based on the tipsy coachman.
Judge.
And I didn't see it in the motion.
Your Honor, there were various, I think we were on our second amendment, which would be the
Correct.
third
Starts
motion.
at 53 record.
Yes, Judge, thank you. Judge, in the actual written motion, it was not, I believe it was addressed in final argument on the motion.
But this is a C4 motion. This says it's a sworn pleading that sets forth all of the material undisputed facts. How can you add a material fact, whether disputed or undisputed, other than through the sworn motion itself or the traverse or demur of the state? I don't understand how we could possibly affirm on additional facts that aren't included within the scope of the sworn pleading of the defense or the traverse of the state.
Well, just like you would consider in a motion for summary judgment in a civil matter, you consider the sworn testimony, any affidavits, and in this particular
Filed
case,
in support of.
filed in support
Filed
of.
in support of.
Correct, and what Judge Pooler did in this case, and the state attorney for Miami-Dade County stood silent and actually suggested to the judge, yes, she said she's going to look at them. And everybody as a group, so to speak, we're all for it because of the novel issues raised here, said, Judge, yes, look at this, look at this. So they were not, in a sense, filed, meaning stamped by the clerk, filed by the defense or by the state, but they were considered by the trial court judge in support of both the argument by the state of Florida and by the defense. So in that sense, filing.
What are the things that she considered? If you can list them for me so that we know what she considered. List for me all of the things she considered beyond the sworn motion and the state's traverse. List for me all the things she considered.
Sure, Judge. I believe she implicitly in the judge's order.
No, I don't mean implicitly. I mean expressly in the record. Show me, point to me where the judge specifically says all of the extrinsic evidence or the additional evidence or the supplemental evidence that she considered in ruling. Other than in her order, because that only tells us what she based her motion to dismiss on. It doesn't tell us the universe of things that she considered. Because if we look at other items and they create material issues of disputed fact, then of course we'd have to reverse, right? I mean, the whole idea of a sworn motion to dismiss is to limit the universe of facts so the court can decide as a matter of law, and so upon review, we can decide whether as a matter of law that limited universe of facts entitles the defendant to a dismissal, right?
Correct.
All right. So now we've expanded the universe, and I just want to know what is that universe so that we know upon our review what it is the trial court.
Judge, without pointing to the exact page on the record on appeal, I can tell you that I know that Judge Pooler indicated on the record that she looked at the depositions in this case.
How many depositions are there in this case?
The two that she looked at were Detective Arias and Detective
Ponzi.
Correct.
Unfortunate name for a case like that.
Yeah, it is. So those are the two depositions.
Are those the only depositions that were taken in this case?
Judge, I don't want. My recollection tells me yes, Your Honor.
Was one of those two people an expert, Arias or Ponzi?
They are law enforcement officers.
Was there an independent expert beyond them?
Yes, that's the testimony of Dr. Evans.
Was Dr. Evans' deposition taken?
No, he was not deposed. He testified at the C4 in support of the defense, but also was cross-examined by Thomas Haggerty on behalf of the state.
Right.
Judge, going back to the money laundering, why I think it can be disposed of, at least as to count two, was that in order to have a financial transaction, you would need
Your argument is that it's counterfeit money.
With the counterfeit, yeah.
well, that's part, yeah, correct, that's part of it. You can't have an exchange or a laundering with counterfeit money and or the Bitcoin without using a financial institution.
So let me ask you to wrap up then.
Yes. Well, Your Honor, simply put, just looking at the statutory definitions and applying the rule of lenity, which was argued by the defense here, that a person such as Mr. Espinoza, who has his personal Bitcoin to sell, would not have known that this would violate any statute. The language as it exists today in the Money Services Business Statute is so broad when you define these things that we believe that Mr. Espinoza is exempted from licensure in this particular case. As far as money laundering, I think one of the large considerations of the court is after this particular case, I believe the Miami-Dade State Attorney's Office went to Tallahassee and lobbied, and in fact, that statute has now been changed.
Some of the definitions were changed.
The definition was set to include virtual currency because that was something new here that I think.
And what significance should we take from that? How should that affect or bind us?
Well, I think that is at least some acquiescence on the part of the state of Florida that the statute needed to be amended so it was clear and would include perhaps conduct such as my client. Obviously now they can't be ritual.
It certainly doesn't stop the state from arguing that the pre-amendment statute, the statute we're working under, included Bitcoin.
Absolutely not.
Okay. Because obviously if they go into Tallahassee and the legislature refused to amend the statute, they would be entitled to that same presumption that the statute must have included Bitcoin because the legislature refused to amend it, right?
That's correct.
Okay, so you know it cuts both ways, but I agree with you, perhaps some evidence that they had concerns about the clarity issue.
Yes, sir. Thank you. Thank you, Your Honors.
Thank you.
Thank you. So some brief rebuttal.
Yes, Your Honor. First, as to the factual question, I'm pointing the court to the District of Maryland case, site 50.44 Bitcoins. That involves people, individuals, who had and they determined that the Bitcoins could be seized as the proceeds of an illegal money transmitting business. So to the extent that there's some concern about lenity or there's no authority out there or something about the facts of this case, I think that case is pretty clear. Also, with regard to Florida authority, we cite the Jennings case and the Hopkins case. The Hopkins case involves a catch-all. I know some of the members of the panel thought that the catch-all was broad, but there is Supreme Court authority saying, if the catch-all is plainly applicable, we can enforce the statute. And with regard to the money laundering counts, I would stand on the argument in the brief with regard to our contention about how the transaction is what's at issue, and that if you attempt to engage in the transaction, that's what we look at. You look at what Mr. Espinoza did, not what the agent did with regard to the counterfeit money. And if there's no further questions, we request that the court reinstate the information and allow the case to proceed towards trial.
All right, very good.
Thank you, Your Honor.
Thank you both.
Thank you both.
And
Very
in case they're watching, we'll also thank the amicus for a brief.
All right. What is adjourned?